I call this meeting to order. Welcome to meeting number 62 of the House of Commons Standing Committee on Citizenship and Immigration. Before we begin, just a few housekeeping notes. You will notice that our regular clerk, Stephanie, is not with us today. She has taken an indefinite leave, and I hope she will be back with us very soon. Until then, Keelan Buck will be filling in. Welcome to CIMM, Keelan. Members can reach him via the General Committee email. So welcome on board, Keelan. In regards to scheduling, on Wednesday, we have scheduled former Margano for 1 hour and D&D officials for 1 hour on the Afghanistan motion. We intend to begin consideration of the application processing times draft report next Monday. I would note that as the committee has prioritized legislation, these meetings will be moved back as needed until we have finished the S245. Also regarding today's meeting, I have verified with the House administration, and they have informed me that the resources are not available to meet for more than 2 hours. Today, we will be going through Bill S245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Pursuant to the order of reference of Wednesday, November 16, 2022, the committee will resume consideration of Bill S245, an act to amend the Citizenship Act. Before we begin, I just would read some instructions so that all the members understand how this meeting will proceed. I would like to provide members of the committee with some instructions and few comments on how the committee will proceed with the clause-by-clause consideration of Bill S245. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are no amendments to the clause in question, I will recognize the members proposing it who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill or in the package each member received from the clerk of the committee. Members should note that amendments should be submitted in writing to the clerk of the committee. I will try to go slowly to allow members to follow the proceedings properly. Amendments have been given an alphanumeric number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. In addition to having it to be properly drafted in a legal sense, amendments must also be procedurally admissible. The chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. A ruling of the chair is non-debatable, and the only resource is to appeal that decision. If you wish to eliminate a clause of the bill altogether, the proper course of action is to vote against that clause when the time comes, not to propose an amendment to delete it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments as well as an indication of any deleted clauses. Thank you. I hope everyone is clear. Yes, Mr. Kimmich.
Just, Madam Chair, because you had said that we can't move new amendments, but at table, every committee I've ever been on, clause by clause, if an amendment does come to a member's mind, they can still read it into the record, and then it can be distributed to the rest of the committee. That goes beyond the package.
Made it clear that yes, the amendments can be moved on the floor. Before we start, okay, good. So, Ms. Kwan.
Sorry, Madam Chair. Just one further question of clarification before I move the First Amendment. In the event that we don't finish these amendments today, so that is to say we don't finish the package for S245 to be referred back to the House, then this debate will then carry on to Wednesday. Former Minister Mark Garneau is supposed to come before committee on Wednesday. So that would mean then that the clerk will try to reschedule Minister Mark Garneau. Am I right in understanding that process then?
So in regards to Bill S245, we have already got one extension. We cannot get any further extension, and we have in our motions we have said that the legislation takes a priority. So, if in case we are not able to finish clause by clause for Bill S245, we will have to take this up on Wednesday, and then reschedule the meeting with Mr. Garneau. And it's 1 hour with what we have scheduled right now is 1 hour with Minister Garneau, not Minister Garneau, like Honorable Garneau, and 1 hour with the D&D officials. So we will have to reschedule it. Thank you. Ms. Kwan.
Sorry, one other question. I just want to get all the Afghanistan witnesses issues, and can we get a quick update on the other ministers who are supposed to come before committee? Do we have dates scheduled for them? And how would they be impacted with sort of delays?
In regards to the motion passed and the meetings which have been scheduled, the only missing minister is Minister Marco Mendicino. We have not received any notification in regards to when he can come. So in regards to the date, all the others have been done. Yes, Ms. Kwan.
Thank you very much, Madam Chair. I assume that the clerk will continue to work to get the minister before the committee. So with that, I'd like to then move my First Amendment, if I may, Madam Chair.
Yeah, let me just begin. So new clause 0.1, NDP 1.
Yes, correct. Yes. Thank you very much, Madam Chair. This amendment aims to address the second-generation cutoff rule. Committee members will know that in 2009, under Bill C-37, this right for Canadians to pass on their citizenship to children born abroad was taken away. And as a result, it has created a new class of lost Canadians, and that's been extremely problematic. And so that was done back in 2009 by the Conservative government. So this amendment aims to restore that right to those individuals by establishing a connections test to Canada. And I'm proposing that we establish the connections test by 3 ways. One, that the person has been physically present in Canada for at least 1,095 days, and that the person has been registered as an elector or future elector under the Canada Elections Act, and that the person has studied at an elementary, secondary, or post-secondary or vocational school in Canada, or that the person has been employed by the Government of Canada or been a representative or delegate of Canada at an international organization, summit, or forum. I'm moving this amendment, Madam Chair, because I think that it is important to recognize those lost Canadians. If they meet any one of those connections tests that I've highlighted, I think that they should be able to have the right restored to them. Madam Chair, at this point, I'm just wondering, should I read out the content of the amendment as it is drafted by the Legislative Council, or can I just say that I move NDP 1?
You don't have to, but if you want.
Okay, I won't. I will spare everybody the pain. I think I've explained what this amendment is purported to do, and so to that end, Madam Chair, I'll move NDP 1, Amendment NDP 1.
Thank you, Ms. Kwan. Ms. Lalonde.
Je voudrais remercier ma collègue pour...
I'd like to thank my colleague for this amendment. I would like to put forward a sub-amendment.
Propose a sub-amendment to limit the definition of substantial connection. I move that NDP 1, proposing to add clause 0.1 to Bill S-245, be amended at paragraph D by adding the following after the words connection to Canada if, 2 points, the person has been physically present in Canada for at least 1,095 days, and by striking subparagraph I, double I, triple I, and 4. And the explanation of my reasoning is this sub-amendment changes the NDP 1 so that the definition of substantial connection can only be met through physical presence of 1,095 days, equivalent to 3 years, in Canada. The time spent in Canada does not need to be consecutive. Merci, Madam Chair.
So now we have a sub-amendment on the floor, and I have a speaking list. Ms. Rampel-Garner.
Thank you, Chair. I'll direct some questions to officials with regard to the sub-amendment. Does the department have the resources or a system to determine physical presence per the description in the sub-amendment? And if so, what mechanism would that be? Would it be consistent? How would someone verify substantive presence in this situation? Would you be looking at tax records, receipts? What would somebody have to do to provide substantive connection in this, should this amendment pass?
Thank you, Ms. Rampel-Garner. We have a speaking list. Okay, yeah. Like Ms. Kwan, if you can respond to that. And
it was
then
a question for the officials.
For the officials.
I'm allowed to ask questions to the officials in my speaking.
Okay. Who would like to respond to Ms. Rampel-Garner? Yeah, please go ahead.
Madam Chair, thank you for the question. When legislation is passed by Parliament, we begin the implementation preparations, including developing changes to policy guidelines for decision makers on a range of types of proof that could be accepted for the purposes of demonstrating things like a connection test and the types of evidence that the member was mentioning. Thank you.
I'll continue. So have you given, has the government asked you for any advice on how a substantive presence test could be proved should this amendment be passed?
Yes, please go ahead.
Thank you, Madam Chair. I'm not aware that any advice on this question has been provided to this point. As I mentioned, the implementation preparations begin once legislation is passed by Parliament. Thank you.
And so is it fair to say that at present, there isn't a system to prove substantive connection per the way that the amendment is laid out. Is that done in any other similar legislation right now? And if so, how is that done?
Madam Chair, as the committee may be aware, currently citizenship applicants are required to demonstrate 3 years of physical presence in Canada for the purposes of fulfilling requirements to become Canadian citizens. And so we would build on those systems and processes we currently have in place with regard to any new legislative requirements that we may be implementing down the road. Thank you.
I guess what I'm not clear with this amendment, and my concern is I'm not sure how many people it applies to, and perhaps if it's broadening a scope beyond what was intended in the original intent of the bill. Does the department have a sense of how many people the amendment would apply to? Is there any data to that effect? Or how many people it could apply to?
Madam Chair, as I commented on during my previous appearance, the department can't speculate on how many persons would come forward who could benefit from these provisions in future. But it's fair to say as a frame of reference, we could refer to the current number of persons, Canadians who are born abroad, who apply to the department for what we call a proof of Canadian citizenship, which tends to be between 40 to 60,000 such Canadians per year. And so it would be reasonable to assume that there would certainly, could potentially be a number of thousands of applicants who could come forward should these changes be passed by Parliament. Thank you.
Thank you. And do you have any sense, could you give the committee a sense of sort of what the delta is between what the original bill, like how many people would be affected by what the original bill proposes and what this potential change that we're now debating could mean in terms of additional applicants?
Yes, thank you for the question. So as I believe I referenced in previous comments to the committee, there were sort of two main aspects of the bill, the original bill, impacting volumes that the department could be called upon to process should the bill be passed. The one was the very small cohort of so-called lost Canadians under Section 8. And then there was the second provision of the bill, which was from the perspective of the analysis of the experts at this table, including my colleague from the Department of Justice, that was impacting the first generation limit and moving the line on the first generation limit from our analysis, which I mentioned could impact in the tens of thousands or more of persons born abroad. I think it would be fair to say, and we'll see during clause by clause what transpires with that second part of the bill, that the motion proposed by the member here is certainly one that could extend to a number of thousands of Canadians who are born abroad in the second generation and beyond. But the number is really dependent on the number who come forward. And that is something that we can't know in advance. And I think that that's the sort of the best, I'm estimating to the best of my ability based on what we know at this time. Thank you.
Thank you. Was the was that potential additional amount of people that you're referring to now, and I understand that it's dependent on what actually passes, doesn't, but you say it could be several thousands or more. Was that accounted for in this year's immigration levels plan and targets?
Madam Chair, the immigration levels target, while outside of my remit, I'll be clear, relates to the number of permanent residents who immigrate to Canada, the target for that in the year. With regard to this cohort that's being discussed now, it's with regard to persons who would be considered Canadian should the connection test outlined be met. And so those persons would be eligible for a proof of citizenship as automatic Canadians, and so they would be outside of the levels process, if I can put it that way.
Thank you. Okay, so my understanding from reading the testimony and the original intent put through the other place on this bill was to keep the band of focus to a very narrow cohort, such as the scope of the private members bill. What I'm concerned about is that we are now amending the bill significantly out of scope, which to the testimony here could impact unknown thousands of persons, perhaps hasn't been given thought in the broader context of Canada's immigration goals and policies. And for that reason, I think that it should be brought forward in government legislation as opposed to amending a private members bill through a process that, frankly, was we had to go through a motion in the House of Commons to extend the scope. And I understand that, as Canadians, we want to be an open and welcoming country, and that immigration is a core and vital part of who we are as a nation, and that the government has an onus to welcome people. But we also have to do it in such a way that we are coordinated and thinking about all of the resources that we need to address appropriate integration, ensure fairness and equity. And my concern is that by amending a private members bill in a way that is very much out of scope to what was first approved, that we are now, this is, and the department is saying that we don't know how many people could be impacted by this. For us to consider this just at clause by clause without having a fulsome analysis from the minister and whatnot, I think it's, it doesn't fit within the responsibility of what we've been tasked with here. I think that by amending this without, further diligence, or without the government putting forward a bill on this, or another private members bill, it sets a poor precedent. So my argument, colleague, just based on the chair, based on the testimony from the department is, we don't know how the test would be applied. We don't know how many people it would be applied to. The estimate is in the thousands. That hasn't been talked about in any way in the levels plan. And now we are going well beyond the scope of the initial mover. And for all of those reasons, I would implore my colleagues perhaps to either withdraw the amendments or to vote against them, and then to perhaps, we could issue a report as the committee after we go through clause by clause on this with recommendations to the government on other things that they should include in future government bills, like the things that are being proposed here. I would be more comfortable with that as a legislator. Otherwise, I would just implore colleagues to think about this precisely and rationally, as opposed to essentially putting forward government legislation through a private member's bill from a senator. I just think it's grossly irresponsible. Thank you.
Thank you, Mr. Rempel-Gardner. I have a speaking list. Mr. Reddycop is next.
Thank you, Madam Chair. Just for the record, what my colleague just said, I would say ditto instead of repeating it all. But I just have a couple of quick questions to the witnesses. You had mentioned, Ms. Gerard, you'd mentioned that in talking about the physically present testing, that it was similar in concept to what we're doing right now for PR and other applications. What is the test then that would be used? Because presumably some of those methods could then be ported over to this system. So what actually are the methods that are used today for that?
Ms. Gerard?
We have policy guidelines in place with regard to assessing the applicants have been physically present in Canada for 1095 days. So initially, an applicant has to do a self-assessment and a declaration. If there's any issues, there are a variety of proofs that can be considered. Those guidelines are sort of a matter of public record and could be provided to the committee, if that would be helpful. Thank you.
So, just a bit further on this. So, you're saying it's an attestation that the person says, yes, I've been here for 1,095 days, and then the department would, after that, maybe come back and review some of those. Is that what you're saying? And if so, what's the process that would trigger that, and how does that work?
Madam Chair, I don't have all of the details available to me to hand this afternoon, but we could certainly endeavor to provide that information to the committee.
Okay, so I get that it's a big scope of things here. So, but is it fair to say that the process generally is you sign an attestation, or the applicant signs an attestation, and then the government, after the fact, may or may not come back and double check that and have some methods to prove that. Is that the general idea?
Yes, that's correct.
Okay, and then just one other question. If this sub-amendment doesn't pass, just curious about the Canada Elections Act, does RCC have access to that data in order to see and confirm that what the electoral status of that person would be?
Well, Madam Chair, there are legal authorities that carefully govern what information we're permitted to have access to, and they have to be for consistent use. So it may be that on the application form, the applicant is ticking if we're permitting to share information of new citizens with Elections Canada for the purposes of exercising their rights. But it's not my understanding that information is currently in the other direction in response to the member's question.
So then the answer is, so what you're telling me is that it would be actually very difficult to implement that because IRCC doesn't actually know if they've been registered as an elector. That's what you just said. Am I correct?
Yes, I think that's a fair characterization. Thank you.
C'est tout.
Thank you. We will now proceed to Ms. Kwan.
Thank you very much, Madam Chair. I'll just respond very quickly on the sub-amendment. I would prefer to actually have a more broader categories of someone establishing a connections test, such as the items that I had initially included in my amendment. However, that being said, in the spirit of collaboration, I understand that the government wants to limit it to only applying the 1095 days of physical presence. While I don't like it as much as the amendments that I table, I will support it because I do want to see this package to move forward. I think it is important to restore the birthright of these lost Canadians. And because it's a birthright, it is not an issue that would impact the levels plan, Madam Chair. So with that, I will support the sub-amendment as tabled by the government, although I like it less than what I have tabled myself.
Mr. Dhaliwal. Mr. Dhaliwal? You are on mute. Mr. Dhaliwal, you raised your hand, so do you have...
Yes, Madam Chair.
Please go ahead.
Madam Chair, when Conservatives brought this second class of citizenship, there was a uproar in many different communities. I still remember that, and there are people that lost their MPship because of this particular class that was brought forward. And now putting 1095 days, I still am not very happy, but I will be able to support the sub-amendment. The way I see it is this, because Canada is a knowledge-based economy. Let me say one professional, and it's a perfect example in my own home, is an engineer or a doctor or an accountant or a consultant. That person goes and works for a Canadian company overseas, for many, many years, and their child is born there, and how that child will be able to come back and prove that they are able to live for three years in Canada. So basically, we are still considering them as a second-class citizens. The child can leave their parents until it is adult. So I can give you a perfect example in my home. My brother, who's a professional engineer, who's working for a Canadian company. He worked in many countries, and his son was born in Suriname. Even though at that time this law didn't exist, so he became Canadian citizen right away because the parent was a Canadian citizen, and my brother still is a Canadian citizen, and he's been stationed at different places throughout for that engineering company to manage their offices. So, and I'm sure there are many others like that, and it still bothers me that we are considering this as 1095 days, even though I will be able to support, but at the same time, it comes to me as a second-class citizenship if someone can respond.
Thank you, Mr. Dhaliwal. Mr. Dhaliwal, would you like the officials to respond to it? Ms. Gerard, would you like?
Either the officials or Ms. Kwan brought this forward as well, and Ms. Lalonde as well.
Comment on it?
Well, I'm not sure that I would comment, but what I could point out is that the 1095 days is the same connection test that a newcomer to Canada needs to demonstrate. And so from that perspective, it is consistent in terms of the policy that Canada currently has on attachment to demonstrate. And then the other consideration in terms of what the member was outlining is that my understanding of the motion is that it's backward looking, and it's addressing the concerns of parents and stakeholders who have come forward to this committee to express that parents in their lifetime have demonstrated an important connection to Canada through their studies or their work history or some combination thereof, and where they've already demonstrated in the past that connection of 3 years, then my understanding of the motion is that that child would, born abroad in the second generation or beyond, would be considered a citizen, whereas now that's not currently the case. Thank you, Madam Chair.
I have on the speaking list is Mr. Kimmich.
I'm worried that Mr. Dhaliwal, by voting for the sub-amendment, would cause himself family strife at the dinner table, and I really don't want to do that. Just to the officials, quick question. About a decade ago, the department used to do, it was called day counting. You would get these large applications in to prove the 3 out of 5 years was 4 out of 6 at one point. And you would do that by providing passport pictures of the stamps inside it. Now it's all digital electronic. You would provide utility bills, whatever to prove literally day to day if you're traveling for work while a PR. That's been totally discontinued now. It's only a declaration that you click off on.
Madam Chair, as I've mentioned, and just further to the member's question, things have changed, I think, to some extent since then in terms of there may be different tools that are available to officers, but I don't have the information to hand today. So I'll be pleased to provide those guidelines that support that kind of decision making and how those assessments are made to the committee. Thank you.
That's a pretty substantial answer to get, because if we're creating an administrative burden for the department, especially 1,095 days that could be parsed out over many, many years, the older the person is, the more series of days or weeks or months or years they could be in Canada. If they travel back and forth for whatever reason that is, and then make an application through the system, if it's just a declaration, the government after the fact would have to demonstrate. So that's a different administrative burden than to go figure it out. And then I think it'd be much easier to say consecutive or successive or something like that, because then it would take basically someone to live here, to go to school here, they've worked here, they've established themselves for several years. And that would be an easier thing to prove to the department that you were here for an extended period of continuous time in Canada and therefore have that substantial connection that is easier to prove, so the department then would have an easier way to understand it. But I think that information is actually really critical for us to understand because that day counting, if it's not being done anymore and it's just an attestation, then the government will have to spend more time on the back end double checking everybody's declarations when they submit them. So I think that would be problematic without maybe another sub-amendment to this. I know you can't move another sub-amendment to say something like continuous or successive, just so it's like 3 continuous years. So you could go to school here for 3 years, like high school or elementary school or something like that. That's just thinking out loud, Madam Chair.
Next is Mr. Maguire.
Thank you. I think Mr. Kimmich read my mind. In regards to the 1,095 days, I believe Ms. Lalonde indicated that could be accumulative as opposed to consecutive. And the more that you have that, it seems to me, if you're trying to keep track of it, it's a much more difficult thing to do. And in regards to my colleague, Ms. Rempel-Garner's first question, how much more does that complicate the situation then? That's one of the things that's what first came to my mind, and I'll ask the officials if they can expand on exactly what it is now and what this change would make. And how much more difficult that might be. Thank you.
Thank you, Mr. Maguire. Ms. Gerard?
Thank you, Madam Chair. There are many who have made representation since 2009, and I believe to this committee as well, about having grown up in Canada and yet not having access to the kind of mechanism outlined in MP Kwan's amendment. And one of the most often cited examples of people who make these representations is, I did my schooling here, my university here, worked here. So typically for individuals for whom that's the case, if they're having a degree from a Canadian university where they've done a 3-year or a 4-year degree, it will be fairly straightforward and one piece of evidence to demonstrate a 3-year physical presence connection test typically. There'll certainly be circumstances outside of that, but there may be other ways and other things to look at in those other kinds of cases. Thank you, Madam Chair.
Done. Ms. Rempel-Garner?
Thank you. Just a question to build on one of the answers that just came up here. So again, going back to the previous answers that you've given in the committee, my understanding is that what this amendment would do is it's essentially conferring citizenship on certain persons should they come forward to request it and they meet the criteria outlined in the bill, correct? Okay. So in that situation, is the typical sort of screening process that would go through an application for somebody to immigrate to the country through other means, would that be applied in this situation or not?
Ms. Gerard?
Madam Chair, no, that wouldn't be the case, because my understanding of the criteria in the motion put forward is that the person has to have a Canadian parent. So that has to be established, just like any proof application that's submitted to the department now. And in addition, in order to access Canadian citizenship, the connection test will have to be demonstrated, such as through the example that I've given through the comments that I've made previously. And so that is more akin to a proof of citizenship process in terms of what the department processes now. It doesn't relate to the immigration process example. Thank you.
Thank you. So thank you for that clarity. So given that this amendment could potentially impact thousands of persons who wouldn't be going through a typical screening process for a new Canadian, would just be conferring citizenship on them, has there been any sort of impact analysis done or potential risk assessment, the sorts of assessments that would be done prior to announcing a new immigration program or a pathway to enter Canada. Has there been any sort of analysis done within your department on the amendment, the type of process that's being put forward in the sub-amendment?
Madam Chair, I'm not aware of any such analysis. However, what I could offer the committee as someone who is sort of supporting the parliamentary consideration for the third time of measures intended to restore citizenship to additional lost Canadians is each time there is maybe, if I can say, a bit of a risk to overestimate the number of people who may come forward. And as I mentioned to the committee on a previous appearance, between the 2009 and 2015 amendments that were similarly conferring citizenship to a number of cohorts of lost Canadians, we had just under 20,000 persons come forward to take up that opportunity to apply for an oath of a certificate of Canadian citizenship. And so, thank you, Madam Chair.
So you just mentioned an interesting point, and I'm trying to get a sense of if it applies in the situation of the sub-amendment here. There have been previous attempts to clarify lost Canadians. It seems to me that like any time there's a bill or a measure put in place to clarify lost Canadians, there's like another class of lost Canadians that seem to sort of come in on the back end. Do you think that, or perhaps have you given any advice to the government, or has the government asked for any advice that as opposed to continually amending the lost Canadian component, that perhaps there needs to be a broader class and a more definitive class of what would constitute this, and then kind of just draw a line?
I'm not aware of any such advice currently, and I think it's you know, the consideration is up to this committee's deliberations, as we know. The last rounds having been done in 2009 and 2015, but at that time, the focus was on eliminating the problematic aspects with regard to the previous Section 8 provisions, which caused the second generation and beyond to lose citizenship automatically from age 28 if they didn't take measures to retain it, and replace that with a clear first generation limit. And the discussion now is beyond the first generation limit. What is the view of the committee today with regard to this motion on those who have parents who can demonstrate a strong connection to Canada with regard to those second generation descendants and a pathway or an access to citizenship? Thank you.
Based on what's being proposed in the sub-amendment here, does your department foresee, or perhaps could you clarify for the committee any potential like additional people that would then come forward and ask for extensions in this? Like, I guess, how to phrase this differently. What I've seen since the original fix that was put forward is the definition keeps moving forward, right? And anytime that there's one group that gets fixed, it's like, oh, well, now there's another cohort over here that could apply. And what I would rather us, take a position on is just like having a more concise and clear definition on where to draw the line so that we can be fair and equitable in our immigration process. Like what I'm concerned about here with the sub-amendment is that we are essentially conferring citizenship without having to apply for citizenship to an untold number of persons, while there are literally tens of thousands, hundreds of thousands of persons in a backlog trying to come to Canada, even just to immigrate as a PR. I'm just concerned that with this amendment, we are creating automatically conferring citizenship to a group of persons that at the same time there's tens of thousands, I don't know what the backlog is now, but people trying to come to the country in other ways. Do you have a sense in the department of how many people are on that would be affected by the sub-amendment have already applied for citizenship already through another stream?
Madam Chair, I'd have to check which statistics we may have to subsequently provide to the committee. But as I referenced previously, we have about 40 to 60,000 applications for proof in any given year for the children born abroad in the first generation who are citizens currently. And so the question is about the numbers beyond that, likely in the thousands, who currently, as this committee knows, have to go through the immigration process, which means that they will need to be sponsored by their parents, become permanent residents, and then go through the second process of applying for citizenship. From a certain perspective, the amendment put forward by MP Kwan could be seen as a more efficient process, because essentially it's looking to extend citizenship to the same cohort without having to go through the immigration process first, on the main condition being that the parent demonstrate the 3-year connection test under the sub-amendment proposed by the MP Lalonde. Thank you.
Thank you. Just with regard to your last comment, have you given advice to the government to that effect, that perhaps prioritizing, how to put this, allowing people to show proof of citizenship through this potential route that's being proposed in this amendment would be more efficient than encouraging people to apply for residency through other immigration pathways?
When asked about the impact of this proposal, yes, we have observed that currently, since 2009, families in this situation are required to go through the permanent resident route, because there is no immediate pathway to citizenship for the second generation born beyond, which does mean that under this proposal, there is a step that's saved. That's accurate. Thank you.
Thank you. So would it be fair to say then that given what was just presented, Chair, by the department, that if this amendment passes, we are prioritizing citizenship and access to Canada for a cohort of persons that we hadn't previously prioritized over people that are perhaps in the queue already for other immigration pathways?
That's not accurate, actually. Before 2009, the second generation and beyond were automatically citizens, but lost their citizenship automatically on their 28th birthday if they failed to retain it. And the issue was that those of us who were born abroad didn't know, because there was no centralized register to advise us. And as testified by others in front of this committee, it led to all kinds of problems, which in turn created the drive for this proposal. And so while the first generation limit in 2009 eliminated that problematic regime, if I can put it that way, and put a clear regime in place, it still left out the second generation born abroad whose families had a significant connection. Thank you, Madam Chair.
Thank you.
Great. We have a sub-amendment on the floor, so we can vote on the sub-amendment. Is everyone okay with the sub-amendment?
No.
Anyone opposed to the sub-amendment? No? So we have NDP 1, the clause as amended. Mr. Reddycop.
I would like to propose another sub-amendment. Sure.
Just to clarify, we have NDP1 as amended. I would just read it so that everyone knows that motion number 12263633 proposing to add clause 0.1 to Bill S245 be amended by substituting the following for that clause. Subsection 2 of the Citizenship Act is amended by striking out and at the end of the paragraph B by adding and at the end of the paragraph C and by adding the following after paragraph C. A person has a substantial connection with Canada if the person has been physically present in Canada for at least 1095 days. Okay, Mr. Reddycop.
Thank you, Madam Chair. So I have a sub-amendment to that, and it's very simple. So just to give it a bit of background, I'll tell you what I want to do. I want to add the word consecutive in between 1,095 and days. So in other words, has been in Canada for at least 1,095 consecutive days. Now, the logic of this goes back to Ms. Kwan mentioned that she liked her original motion or her amendment with the additional more detailed criteria. And then what Ms. Lalonde proposed was a much simpler criteria. And so this is a little bit partway in the middle because it does make it a little bit tougher to meet a consecutive clause. But then we also heard from our witnesses who said that the most common thing that they hear is that somebody studied here in school. For you talked about university or other things, and you said in those cases it's very easy and straightforward to prove that. And so to my way of thinking, this isn't a difficult test to match, and it's also much simpler to prove at the end of the day when it's consecutive. And so I would, that's why I would move this sub-amendment to put consecutive in there between 1,095 and days. And I think that would be a stronger test, and I don't think it's adding a lot of burden to either the people. It actually simplifies the department's work on this. So that's my proposal.
Thank you. Thank you, Mr. Reddycop. So we have an amendment to NDP1 as amended. So we have an amendment proposed by Mr. Reddycop. Any discussion on that? Okay. No discussion. Is everyone in agreement? No. So I say we will have to take a vote. So Mr. Clerk, if you can please take the vote on the sub-amendment proposed by Mr. Reddycop. So we are voting, just to be clear to everyone, we are voting on the sub-amendment proposed by Mr. Reddycop to NDP1 as amended. Over to the clerk.
Mr. Ali.
No.
Mr. Dhaliwal.
No.
Monsieur Edkoury. No. Madame Kayabaga. Madame Lalonde.
Contre.
Mr. Kimich.
For.
Mr. McGuire.
For.
Mr. Reddycop.
Yes.
Ms. Rampel-Garner.
Yes.
Monsieur Champoux.
Contre.
Ms. Kwan.
No.
Yeas 4, nays 7.
So the sub-amendment proposed by Mr. Reddycop is defeated. So we are back on NDP1 as amended. Seeing no debate, if Mr. Kimich.
It just came to me as I was looking at these, comparing them to some of the other amendments. If this passes, then the only requirement, and I'm just asking a question to the officials, Madam Chair, if this passes, then the only requirement that there will be to regain your citizenship in Canada will be 1,095 days, whichever way the department that administrates that check. What about those with criminal records from a foreign state where they're convicted for whatever overseas?
Ms. Girard?
Madam Chair, my understanding of the amendment is that it's extending citizenship automatically to those born since 2009 who have a Canadian parent, which is the first requirement, and then where the family member is demonstrating the connection test. And so criminality would not enter into the criteria or the assessment. Thank you, Madam Chair.
And seeing no further debate, we will take a vote on NDP 1 as amended. Mr. Clerk, if you can please take the vote. We are voting now on NDP 1 as amended.
Mr. Ali,
Yes.
Mr. Dhaliwal,
Support.
Monsieur El Khoury, Madame Kayabaga,
Pour.
Madame Lalonde,
Oui.
Mr. Kmitch,
Against.
Mr. McGuire,
No.
Mr. Redekop,
No.
Ms. Rempel-Garner,
No.
Monsieur Champoux,
En faveur.
Ms. Kwan,
Yes.
yeas 7, nays 4.
Carried. So NDP 1 as amended is carried. Now to clause 1. Ms. Lalonde and then Ms. Rempel-Garner.
Yes.
Ms. Lalonde and then Ms. Rempel-Garner.
Okay, go ahead.
Yeah.
Thank you very much, Madam Chair. I would like to bring, I move that Bill 245 in Clause 1 be amended by deleting line 4 to 8 on page 1. So as written, the bill only remedies the status of some of those who lost citizenship due to the former Section 8. Those who never made an application to retain citizenship. So this amendment deletes the line in the current clause to allow for the introduction of a more inclusive provision through Amendment G3.
Okay, so Ms. Lalonde has proposed an amendment, G1. Ms. Rempel-Garner was next on the list.
I have a chair that I have an amendment that I would like to add prior to clause 1.
Okay, so amendment has
getting
been
advice.
proposed by
I'd
Ms.
like, I'd like to add a new clause prior to clause 1. So that's,
Just 1 second, let me
that's
just
what I had my
ask the
hand up
clerk.
for.
Yeah, 1 second.
we're just getting advice from the clerk.
Yeah, one.
Yep.
Okay. Just for everyone's information, as per the law clerk, if Ms. Rempel-Garner is proposing to go back, but before like clause 0.1, before clause 1, we need a unanimous consent. So, do I have the unanimous consent of the committee to go? No, I don't see unanimous consent. There's no unanimous consent, so we continue with G1. Yes, so there is no unanimous consent. We continue with clause 1, G1. Ms. Lalonde has proposed an amendment for clause 1. Mr. Redekop.
So for my clarification, so this is deleting lines 4 to 8, right? That's what we're doing. So I heard you say, Madam Chair, that if we're deleting lines from the bill, that it shouldn't be proposed as an amendment. It should just be dealt with in the vote for the clause. Is that what you said?
Yes.
That's for deleting the entire clause. This is not for the entire clause.
Oh, I see. So this is
Yeah.
the part of the clause. Okay.
We have an amendment proposed by Ms. Lalonde on the floor for clause 1. Any discussion? Seeing no discussion, so we will have to take the vote on G1. So I will ask the clerk to take the vote on G1, an amendment which has been proposed by Ms. Lalonde. Clerk, if you can take the vote.
Mr. Ali,
Yes.
Mr. Dhaliwal,
Support.
Monsieur El Khoury, Madame Kayabaga,
Pour.
Madame Lalonde,
Oui.
Mr. Kimmich,
Yes.
Mr. McGuire,
Yes.
Mr. Redicott,
Sure.
Ms. Rempel-Garner,
Yes.
Monsieur Champoux,
Oui.
Ms. Kwan,
Yes.
yeas 11, nays 0.
So the amendment proposed by Ms. Lalonde is adopted. Okay, so G1 is carried. Ms. Rempel-Garner and then Ms. Lalonde.
Chair, I move that Bill S-245 be amended by adding the following after line 8. Section 5 of the Act is amended by adding the following after subsection 3. Waiver by minister for administrative delays. The minister may, in his or her discretion, after having reviewed a person's particular circumstances, waive on compassionate grounds in the case of any person who has waited over 5 years for a response from the Department of Citizenship and Immigration with respect to their application due to administrative delays. So, and I'm happy to submit that. Here's my thinking, Chair, on this one. Just in the back and forth from the department on Ms. Kwan's amendment and then the government's amendment, we heard a lot about the impact of we have all heard a lot about the impact of administrative delays on people trying to enter the country through other administrative streams, which there are backlogs. I believe that there's over 2 million cases in the system right now, give or take. There are many situations where persons are waiting over 5 years. And so I think what happens too is that rather than looking at how they can get through the regular system in a sensible period of time, they seek to lobby us, for changes like we're seeing in this bill or whatnot as a way to try and get to Canada. And what I think is problematic is that when these persons come to us.
Madam Chair? I apologize to my colleague. Can we take a break so that we can have a paper copy distributed around so that we can focus on what the colleague is putting forward? And to avoid this, thank you.
We can do that, but before, just need to clarify one thing. The Ledge Clerk would like to clarify procedurally what we have to deal with first before we go to Ms. Rempel-Garner's amendment. So if I can ask the Ledge Clerk to please speak on how we can proceed.
Thank you, Madam Chair. The amendment that was moved is moved at the same line as the amendment G2. And since G2 was proposed ahead of this one, G2 should come first, because first come, first serve when it comes to the same line. But it can be moved afterwards, after G2 is dealt with.
Okay. So we will have to deal with G2 and then go to Ms. Rempel-Garner's amendment. And as per the member's request to have a break, I would say that let's get through the G2 and then we can suspend the meeting for a few minutes so that everyone has the amendment which is being proposed by Ms. Rempel-Garner. So we are on, we will go back to Ms. Lalonde for G2.
So, Madam Chair, I will not move G2.
Now, we will come to the amendment proposed by Ms. Rempel-Garner. Ms. Rempel-Garner.
Point of order. I believe you said that once an amendment had been moved, it needed unanimous consent to be withdrawn. Is that correct?
She has not moved it as...
Oh, okay. Sorry, I thought.
Okay. No, she didn't move it.
Okay.
Because she raised her hand to move it, and it was the notice was given about the amendment. It was in the package.
Okay.
So she has not moved it.
Okay. Thank you.
Okay. So as per the member's request, we will take a little break so that everyone can have a copy of the amendment proposed by Ms. Rempel-Garner, and then we will come to that. The meeting is suspended. Take their seats. I hope everyone, yes. Sorry, Mr. Champel.
Je lève ma main, Madame la Présidente.
I wanted to speak to the amendment, Madam Chair.
Just 1 second. 1 second. As per the advice of the ledge clerk, right now we are on Clause 1, Section 3, the amendment which Ms. Rempel-Gardner has moved can go like in Section 5. So procedurally, we have to deal with few things before we get on to this amendment. So right now we cannot deal with this amendment. This procedurally will fall after NDP 8. So we will...
Just point of order, Chair. I would just note...
Ms. Rempel.
Thank you. I would just note that I believe no motion or amendments are public until they have been tabled. So we should just be careful about discussing even numbers, correct? Thank you.
Like when we come to Section 5 of the amendments and then, so right now Ms. Lalonde is not moving G2, where we are is G3, and if I can ask the member if she wants to move G3.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair. Yes. In fact, I'd like to move ahead with G3.
I move that Bill S245 in Clause 1 be amended by replacing lines 11 to 14 on page 1 with the following. G1, the person was born outside Canada after February 14, 1977, and, before April 17, 2009, ceased to be a citizen because they failed to make an application to retain their citizenship under Section 8 as it read before April 17, 2009, or made such an application, but the application was not approved. So this amendment introduces a more inclusive remedy to restore citizenship to everyone who lost citizenship status under the former Section 8. Those who never made an application and those who made an application that failed. Madam Chair, that will ensure consistency. The people whose citizenship is restored by this amendment are added to the list of those who are subject to the first generation limit.
Ms. Rempel-Gardner.
Thank you. I just want to clarify the intent of this amendment. So my understanding is that in G1, what happens is that functionally the legislation would then automatically make anyone who failed to apply for citizenship in that time cohort between the Citizenship Act and the changes automatically a citizen. And that what is being proposed is to limit the automatic citizenship that's being conferred by excluding the second generation of classes of individuals listed in paragraph 3. And I'm just looking to perhaps the officials would want to clarify. I just want to ensure that my understanding of the amendment is correct.
Thank you, Madam Chair. So this is the amendment which is looking to restore Canadian citizenship to all who lost it under the former Section 8, not just those who never came forward and applied, but also those who applied and for whatever reason their application was not approved, in order to have an equitable and inclusive remedy for those lost Canadians.
Through you, Madam Chair, to Ms. Gerard. Thank you. Could you give us some sense of, was it a uniform, and I'm sorry for not knowing this, was it a uniform reason why those persons' applications weren't approved?
Ms. Gerard.
Thank you, Madam Chair. So as I mentioned, this is a requirement which was required to be demonstrated since 1997, so we wouldn't necessarily have access to all of those reasons going back in time. But what we can say is that these are individuals born abroad in the second generation and beyond, and the main requirement that they had to demonstrate was 1 year of residence in Canada. And so if the decision maker wasn't satisfied that that connection test was demonstrated, then the application wouldn't have been approved. That was the main thing that they had to demonstrate.
Thank you. So, Ms. Gerard, then functionally, if this amendment passes based on what has passed already, there would still be a residency test that would apply, correct?
Ms. Gerard.
For these, there is not a residence test in the restoration of Canadian citizenship that's being proposed for this limited cohort. The issue is that they were Canadian citizens until they turned 28, and unbeknownst to many of them, they lost citizenship automatically for those reasons that I mentioned. Often they didn't know that it was a requirement that applied to them, that they had to apply and meet it, and so on and so forth. And so, consistent with previous legislative changes, like the ones done in 2009 and 2015, this is intending to restore citizenship to them automatically, provided that they're described in that limited cohort of impacted by the former Section 8, which was repealed.
And just the last question. So then, what I'm just trying to get at here is, for the cohort that this would remedy that weren't approved in the first place, would there be any instances where they weren't approved for like security means or other issues that could could be material like around Canadian safety? Or is it like, this is just more of like an administrative issue?
Yes, Madam Chair, I would agree with that characterization. It's security and background checks were not part of the original criteria. So similar to cohorts who were restored under previous initiatives, this is a straight restoration for those who fall within that limited cohort who lost it at age 28 because of the former Section 8.
Thank you, Madam Chair. So I'm just, this is very complicated stuff, and so I just wanted, for my simplistic mind, understand. The way I understand this is that the original wording that was in Senator Martin's bill under her Section 1, subsection 1 and 2, is being replaced by these words to essentially accomplish what she was trying to accomplish, but with wording that that the government and government lawyers are more comfortable with. Is that a fair characterization of this?
Ms. Gerard?
Madam Chair, I would agree with that statement in the sense that this is proposed to be a more inclusive remedy, one that's more equitable, and to some of the concerns that were expressed by members previously, to ensuring that all of the lost Canadians in this limited cohort have a remedy. Thank you.
Thank you, Mr. Redico.
So when you say more equitable, because I believe one of the things that is in here that wasn't in Yonah Martin's bill was it includes those who were previously rejected with citizenship and now they're allowed to have it. So is that what you're meaning by more equitable?
Yes, that is correct, because they came forward and applied, and so presumably could demonstrate in some sense that they had a connection to show, whereas persons who never came forward, we don't know if they were in a position to demonstrate a connection test or not. And so if you follow that through to its logical conclusion, the bill as drafted, extending citizenship and a remedy automatically to those who never applied, may be benefiting persons who may or may not have had a connection, but excluding, well, we would suggest perhaps unintentionally, those who could demonstrate some form of connection but were unsuccessful with their original application.
Okay, so I think I'm good with that, because essentially generally speaking, we're following the intent of what the senator intended in her original bill with this. Yeah. Okay.
Thank you, Mr. Redico. None. We will go to the vote on G3, but just before we take the vote, I just want to let everyone know that if this G3 is defeated, Amendment G7 cannot be moved since it refers to paragraph 3.1 G1 that would have been created by G3. So just to clarify, I will ask the clerk to please take the vote on G3. Thank you.
Mr. Ali?
Yes.
Mr. Dhaliwal?
Yes.
Monsieur El Khoury? Madame Kayabaga?
Pour.
Madame Lalonde?
Oui.
Mr. Kimmich?
Yes.
Mr. McGuire?
Yes.
Mr. Redekop?
Yes.
Ms. Rempel-Garner?
Yes.
Monsieur Champoux?
En faveur.
Ms. Kwan?
Yes.
Yeas 11, nays 0.
G3 is carried. Thank you. Now we will come to NDP 2. If I would like to ask Ms. Kwan if she would like to move. Ms.
Yes,
Kwan.
thank you, Mary. Thank you very much, Madam Chair. Yes, I would like to move this amendment. This amendment is to recognize citizenship retroactive to birth for people born abroad between 1977 and 2009 who were not recognized as citizens at birth because of one of the discriminatory rules that Canada had in place, and that the parents were not recognized as a citizen at the time of the person's birth. And so to that end, I'm moving this amendment to rectify that. From my perspective, I think it is important to do this because Canada has had a series of discriminatory policies in place. So take, for example, some of them were gender-based, where an individual, if you were a woman with a child, you would not be able to confer your citizenship to the child. However, if you're a man, you would be able to, as an example. That has now been deemed by the courts that it is discriminatory. And so, but going forward in fixing that, the legislation changes did fix for people going forward, but it did not go back in time. And I feel like that we should actually be consistent with that concept and go back in time to recognize those who actually were not granted citizenship based on their birthright because they were a woman, as an example, because they faced discriminatory rules. So to that end, Madam Chair, I'd like to move this, this amendment.
Ms. Rempel Gardner?
I'm just looking to the department. So my colleague who has moved the motion said that there was discrimination based on gender of parentage. Is that correct?
Ms.
Girard? Well, Madam Chair, the position of the department is that the legislation is compliant. However, the former legislation had a concept called responsible parent, and so what it meant was that citizenship was derived from the Canadian father if the child was born abroad, provided the Canadian father was married, but there was no access to citizenship if the Canadian father was not married to his partner. Conversely, citizenship would derive from a Canadian mother if the child was born abroad, but not if she was married. And so there were individuals who were born abroad to a Canadian parent in either of those scenarios who did not access citizenship. It was not limited to the descendants of women. Thank you, Madam Chair.
Thank you, Madam Chair. So again, it'll be a question to the officials. Is it fair to say this is a different group of lost Canadians than the ones in those 50 months, or is this like a group connected to them? In the Senate testimony, one of the stakeholders that presented said there were about 15 groups of lost Canadians. Is this a different group, or is it a subgroup of those 50 months? Because I'm just reading some of these sections here, and they just make references to paragraphs going all the way to S. And so it's hard to tell exactly which groups are being affected. So can you just clarify, is it a different group of lost Canadians, or is it a subgroup of lost Canadians of those original 50 months that Senator Yona Martin was trying to address?
Ms. Girard?
Madam Chair, thank you. Madam Chair, I'm not sure about the reference to the 15 or the 50 months. However, this is a different cohort than the ones we've dealt with thus far. And I believe that the member is correct that there was testimony. It may have been from the member from the Canadian Bar Association who did reference this cohort, if memory serves. Thank you.
So this is a different group that goes beyond what Senator Yoda Martin had asked to do. That's why we were willing to vote on the previous amendments, because those were basically following the spirit of what our colleague from the Senate wanted to do. If I could just hear from the officials, like how this would function. And like I understand you've explained kind of like somewhat who these groups would be, but how would this function? And how many people do you estimate could be included, impacted by this?
Yes, Madam Chair. It's difficult to estimate. A reasonable assumption would be thousands born abroad, but because the time frame is fairly long, between 77 and 2009, if I heard the member correctly. I think the sort of the concern, and it's one that I've referenced before, is that this particular amendment is looking to extend citizenship automatically to some in the second generation, but not others. So that is the distinction that we would point out for the committee's consideration.
So just on because one of the points here is the first part of the amendment is to give citizenship to second-generation individuals who have deceased parents who were previously lost Canadians but regained their citizenship through a previous version of the Citizenship Act. I've captured it there. Okay. When a person will be, this will be by right or by grant?
No, this is by right. This is conferring citizenship automatically on a cohort who could be described as the descendants of those who were remedied by previous legislative changes in 2009 and 2015, but that only covered the first generation born abroad, right? And so this is a proposal that relates to a certain cohort of second generation born abroad individuals.
So I have a question on back to administration of this. So how would someone seeking to obtain, like say this passed, this became law, how would someone in then the second generation prove that they were eligible for it? They would need a substantial amount of paperwork. The department would have to create a new process for this to be done for these few thousand, potentially few thousand, tens of thousands of people or more?
So, Madam Chair, it would be a proof of citizenship application. That's a process that exists. In this case, because it's second generation born abroad, I would imagine that you would be demonstrating that your parent is an individual who's born abroad in the first generation, so known to the department, or that the grandparent, was born in Canada, or naturalized in Canada, like someone who immigrated to Canada and became a Canadian citizen. And so it's not that far off what transpires in a proof application today. It's just, it would be one generation removed. Thank you.
Okay, can you just make one generation removed? So like I'm a naturalized Canadian, so one generation removed would be one generation behind me?
So in the case of a naturalized Canadian who has a child born abroad, that child is the first generation born abroad and is automatically a Canadian today. It would be the child of that child who's born abroad in the second generation, demonstrating that, look, my parent is a first generation born abroad and known to the department in many cases, because those of us who are born abroad have had to get a proof.
So in preparation for this, I went to go find my you had these citizenship cards you used to do, now you do these big certificates. The cards are way better. Everywhere I meet, we prefer the cards just generally because you can carry them on you. So that would mean that in case of, like, say, my children had children overseas, and they were impacted by something like this, then the way to prove it would be, I would be then their proof. But then my question to you is, because you've now said it twice, known to the department, which means you know that you've issued a card or a document of citizenship at some point? And so all of those documents are digital, correct? Like there's like a digital database of all Canadian citizenships ever issued? Or this is something new to me, so I'm asking whether that's the case.
Yes, Madam Chair, we have those records. I believe in some cases they're actually microfiche. I too have a card and a certificate somewhere in my files. So, but yes, those records exist for the purposes of making those verifications. Thank you.
So just my last question here. So what would happen in a case where, like you just said, you have microfiche, so like archival documents. What would happen in a situation where there was a disagreement between a document provided by a person overseas trying to regain their citizenship, and the department saying, well, our microfiche is not, it's not clear enough, it's damaged or whatever, or the document cannot be found for whatever reason because there's been so many different versions of the act, changes of department, movements of buildings, changes of staff. What happens in those types of situations?
Thank you for the question. Madam Chair, generally the citizenship program is a facilitative program, and the amendment moved by the member is to the effect that these are individuals who would be considered citizens by law. And so as a program, we would be approaching that and looking at, how can we facilitate the access to the person to their documentation, because the law is telling us that person is a citizen. And from time to time, there may be a circumstance such as the member describes where we have to go that extra mile, and the program does. Thank you.
Ms. Rempel-Garner. Ms. Kwan.
I don't have anything else to add.
Thank you. Ms. Rempel-Garner.
Thank you. I just want to build on some of my colleagues' questions, but explore the concept. I just want to see if the amendment actually fixes the problem, I guess. I want to explore the concept of responsible parent, because admittedly I'm not familiar with the history of that term, probably should be. Could the department give us a brief overview of what that concept was and how it was applied to programming and what's changed?
Yes, Madam Chair, thank you. So effectively, this was sort of the legal concept or regime for access to citizenship if your child was born abroad to a Canadian under the 1947 Act. And these are requirements that applied up until the law changed in 1977. And so all of us who are born abroad, and I can include my own example in that if it is useful to illustrate, it means that the Canadian parent was having to demonstrate that their child could legally be considered a Canadian and have access to that proof of citizenship for being born abroad in the circumstance where they fit within that definition under the law at the time of responsible parent. And so it meant that if your father was Canadian, not only that, but your parents had to be married for you to be considered a Canadian citizen. If you were born abroad to a Canadian mother, then your parents had to be unmarried. And if the converse was true, you were not considered by law to be a Canadian citizen or have access to Canadian citizenship. And so that created many lost Canadians. Those provisions were changed in 1977 and were removed to make it equitable, regardless of who was your parent or whether or not they were married. The issue was that in 1977, when the law was changed, those who were excluded previous to then were not remedied. Those remedies only came many years later in 2009. And many of us know people who benefited from those provisions in 2009 to restore citizenship to those who were born to what we would describe as the wrong responsible parent, the unmarried Canadian father or the married Canadian mother where the child was born overseas. I hope that's a reasonable summary. Thank you.
Okay, so just with regard to the amendment that my colleague has proposed, I'm just trying to understand the scope change that it would make from the bill that was originally proposed. And perhaps, I'm not sure if the department is prepared or could comment on that. I'm just trying to get a sense of if it's actually, what the purpose is, like.
Madam Chair, I think the legislative clerk is more the expert on the question of scope, but for consideration, I would simply mention that the narrow provisions of the bill are addressing those who are born abroad in the second generation or beyond, the restoration of the Section 8s, and the committee has just dealt with others who were born abroad since 2009. And so this is a different cohort, but defined in time and particular circumstances. Thank you.
That was immensely helpful. Perhaps could the department just build on that and like specifically define what the cohort would be and perhaps the size as well?
My understanding, but someone can correct me if I'm not summarizing it correctly, but I understood that the amendment is referring to those born between 77 and 2009 abroad in the second generation, who could be considered automatically citizens under this this motion.
And then just to, sorry, Chair, thank you. So then just to clarify, what this is doing is this is not, essentially it would be grandchildren, right? It would be second generation. So as my colleague Mr. Kamek said, and I was valiantly trying to follow his train of logic as well, this is, what is being proposed is that we're expanding the cohort that was in the original bill beyond first generation to second generation that were impacted by the responsible parent issue. Is that correct?
Well, it is, yes, that's correct, addressing those born abroad in the second generation within that time frame.
Have to end the meeting at 5:35. That's we have.
I was just going to say
Ms.
that
Kwan.
this is not related to the age 28-year rule. That's it.
Okay. Seeing no further debate, if we can vote on NDP 2, but just before we vote, just want to let everyone know that if NDP 2 is defeated, amendments NDP 7, page 16, NDP 10, paragraph 22, NDP 11, paragraph 23, and NDP 13, paragraph 29 cannot be moved since they refer to paragraph 3(1)(s) that would have been created by NDP 2. So if we can take the vote on NDP 2.
Mr. Ali.
Against?
Mr. Dhaliwal.
Against?
Monsieur Ali Khoury. Madame Kayabaga.
Contre.
Madame Lalonde.
Contre.
Mr. Kimich.
No.
Mr. McGuire.
No.
Mr. Redekop.
No.
Ms. Rempel-Garner.
No.
Monsieur Champoux.
Contre.
Ms. Kwan.
4.
Yeas 1, nays 10.
So the amendment NDP 2 is defeated. So as I said previously, as NDP 2 has been defeated, amendments NDP 7, 10, 11, 13 cannot be moved since they refer to paragraph 3(1)(s) that would have been created by this NDP 2. So with that, this meeting comes to an end. Do I have the will of the committee to adjourn the meeting? Okay. The meeting is adjourned.
Thank you.